makes you so sick at heart that you can't take part. You can't even passively take part.
Cuba is a hot topic these days, and I want to make a video discussing what is surely the most controversial aspect of the Cuban crisis, which is the embargo. And I think as leftists, we all agree that the embargo is incredibly immoral, incredibly inhumane and cruel, and should end immediately. But I want to make this video about the legality of it. Is the embargo legal under international law? And the reason is because I think this would, if we agree on the morals of it, we still would want the legal case because that would back up the arguments even further. And I also think that we can discuss issues about the embargo on its own. There is a place and there is a space for having a debate on democracy in Cuba, but I think the embargo is a policy that is independent of it. The case for it to be eliminated has nothing to do with whether Cuba is democratic or not. So this is not the space for that debate. And before I start, I just want to give a minor disclaimer. I am not an international legal scholar. I have had a passion for international relations since I was a teenager. I almost ended up studying international relations until I decided on economics. But even then, international law I've always found incredibly boring. So I urge anyone who has any additional information to please include that in the comments. If there is anything that I said that is incorrect, please also mention it. I think the essence of what I'm going to say is probably mostly true, but there might be some details here and there that I might not have interpreted the way a real international scholar, a legal scholar, would have interpreted. So on that note, let us start with the original document, that is the Senate resolution from 1962, which authorized the embargo. And this is a mercifully short document, so we're going to read most of it. And in fact, it's so short that you really have to wonder how much damage you can do with just a couple of paragraphs. But anyway, I'm going to skip this bit. In its final act, resolved that the present government of Cuba is incompatible with the principles and objectives of the inter-American system, and in light of the subversive offensive of Sino-Soviet communism with which the government of Cuba is publicly aligned, urged the member states to take those steps that they may consider appropriate for their individual and collective self-defense. Whereas the Congress of the United States in section blah blah blah, as amended, has authorized the President to establish and maintain an embargo upon all trade between the United States and Cuba. And whereas the United States, in accordance with its international obligations, is prepared to take all necessary actions to promote national and hemispheric security by isolating the present government of Cuba and thereby reducing the threat posed by its alignment with the communist powers. Now, therefore, I, John F. Kennedy, President, blah, 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 hereby proclaim an embargo upon trade between the United States and Cuba in accordance with paragraphs 2 and 3 of this proclamation. Hereby prohibit the importation into the United States of all goods of Cuban origin and all goods imported from or through Cuba. And I hereby authorize and direct the Secretary of the Treasury to carry out such prohibition, to make such exceptions thereto by license or otherwise as he determines to be consistent with the effective operation of the embargo hereby proclaimed, and to promulgate such rules and regulations as may be necessary to perform such functions. And further, I do hereby direct the Secretary of Commerce, and blah, 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 to continue to carry out the prohibition of all exports from the United States to Cuba, and I hereby authorize him under that act to continue, make, modify, or revoke exceptions from such prohibition. In witness thereof, I have here to, well, yeah, that's pretty much it. So, what are the key points here? So, the two things that the U.S. is blaming Cuba is that its government violates the principles of the inter-American system, and two, that it is an ally of the Sino-Soviet communist bloc. So the first thing that I think most viewers might not necessarily understand is what the hell is the inter-American system? What is the legal basis of this? And the legal basis of this is essentially the charter of the OAS, the Organization of American States, which most countries in the Western Hemisphere had signed by then. So to understand whether Cuba is effectively violating the inter-American system, one has to ask whether there are characteristics of the government of Cuba that would be incompatible with this. So basically, does it at any point mention democracy as a requirement to be a part of the inter-American system? And the answer is yes, it does. So the charter of the OAS, which by the way was signed before the UN Charter, so it actually precedes it. Specifically, Article 2 mentions that one of the purposes of the OAS is to promote and consolidate representative democracy with due respect for the principle of non-intervention. Now, Cuba clearly violates this bit because it's not a representative democracy. On the other hand, the US consistently violates the principle of non-intervention. So the US is, you can make the case that Cuba definitely is not a democracy and therefore violates this intrinsic aspect of membership. But if you look at some of the other clauses, the US violates them all the time, like this one: to achieve an effective limitation of conventional weapons that will make it possible to devote the largest amount of resources to the economic and social development of the member states. The US has never, ever, ever followed this particular point. Now, yeah, so the American states clearly mention representative democracy. Again, the solidarity of the American states and the high aims which are sought through it require the political organization of these states on the basis of the effective exercise of representative democracy. So it is a requirement. So yeah, under the basis of the international system, Cuba does violate those principles. On the other hand, the argument about Cuba being a member of the communist bloc, I find this very flimsy, because while it is true that Cuba was a member of the communist bloc, the irony is none of the other members of the communist bloc received embargoes. So it seems really odd that, one of the lackeys of the Soviet bloc was given an embargo for being part of that bloc, while at the same time the ringleader of that bloc, the USSR, never received sanctions. The fact is the US never embargoed the USSR, and there was always trade throughout the Cold War. There was trade between the US and the Soviet Union. It was very minimal trade because the USSR was largely a self-sufficient economy, and so whatever few things it traded, it usually did with its other communist allies, and then only a tiny fraction of trade with the rest of the world. But there was trade. I mean, there were no legal impediments to trade between the US and the USSR, the way that there were impediments with Cuba. So this seems incredibly hypocritical to make an embargo against Cuba on those grounds. And then the other aspect of representative democracy, which is hypocritical, is the fact that there's been plenty of other Western Hemisphere nations since 1962 that were not democratic. All those far-right dictatorships, all those military juntas, many of which, dare I say most of which, were supported by the US. And they were never slapped with an embargo, despite violating the principles of representative democracy that are clearly stated in the charter of the OAS. Now, moving on to the next bit, because the embargo was one thing, but then the embargo was strengthened after the fall of the USSR, which was even more despicable. And there were two pieces of legislation that were passed in the 1990s that intensified the stranglehold of the Cuban economy by this embargo. The first was the Cuban Democracy Act, which was passed in 1992 actually it was sponsored by a Democratic representative. So just to show you how the usually whenever there is bipartisanship in the US, it's for all the wrong reasons. So The Cuban democracy, what it basically did is, again, it lambasted the Castro government for not making any significant changes after the fall of the Soviet Union. And what it does, the way that it goes beyond what the original embargo established, is that the Cuban Democracy Act specifically says that the U.S. was going to seek the cooperation of other democratic countries in this policy. So what it would start to do is not only, the U.S. ultimately can do whatever it wants with whatever country it wants, but now it was going to punish countries that didn't fall in line with its own Cuban policy and basically threaten them. It says here, to make clear to other countries that in determining its relations with them, the United States will take into account their willingness to cooperate in such policy. And there were many ways in which this would be done. So sanctions, for example. The president may apply the following sanctions to any country that provides assistance to Cuba. The government of such country shall not be eligible for assistance under the Foreign Assistance Act or assistance of sales under the Arms Export Control Act. The country shall not be eligible under any program for forgiveness or reduction of debt owed to the United States government. So it basically would shut you out of receiving any sort of U.S. aid. And yeah, there were some other sanctions. One of which was on shipping. So basically, any vessel which enters a port or place in Cuba to engage in the trade of goods or services may not within 180 days after departure from such port or place in Cuba load or unload any freight in any place in the United States. So essentially this was a 6-month ban on docking on any US port. So this was definitely escalating the embargo, clearly. And this was followed up by another more infamous piece of legislation known as the Helms-Burton Act, which passed in 1996. And the Helms-Burton Act basically reinforced the type of actions that were going to be taken to other countries and other corporations that traded with Cuba. And also, equally controversial was its Title III, which was a protection of property rights of United States nationals. Basically, what this title did was that it allowed any company or any individual who was essentially using any kind of property that had been expropriated or confiscated by the Cuban Communist government. If they were using any such property, they could be sued in a U.S. court. So this was really problematic. And all of this basically is problematic from an international perspective because it's applying extraterritoriality to the embargo. It's basically not just limiting it to what U.S. entities, be it U.S. companies or U.S. citizens, could do with Cuba. It was punishing other countries for freely engaging with Cuba. And that was definitely, these laws did not go down well in the rest of the world in any way. I'm going to explain that in a bit. But one of the things that's quite interesting about the Helms-Burton Act is this bit here. So when it's listing all its grievances against the Castro regime, one of them says this: the Castro regime has made it abundantly clear that it will not engage in any substantive political reforms that would lead to democracy, a market economy, or an economic recovery. So this is interesting because this is the first time that actually Cuba's economic model is being mentioned. So all the previous laws were basically focusing on the democratic aspect of the Cuban government and on their alliance with the Soviet bloc. But this one actually does mention that clearly one of the issues that the US has with Cuba is its lack of a market economy. also mentions its economic recovery, which is incredibly hypocritical, being that the embargo is a large reason why the Cuban economy was in such a bad shape during the 1990s. But again, this is very interesting because even though it's not openly stating that it wants Cuba to transition to a market economy, there is a subsequent bit in this law that specifies that basically that the U.S. was committed to regime change and that it would only recognize any transitional government that would be democratic. But it doesn't make any mention of market economy specifically, except here. But I do think this is important to mention because now it's basically saying, hey, we don't like your economic model either. Now, like I said, this act, the Helms-Burton Act, was very controversial, and a lot of other countries made laws to basically counter it. So if any one of their citizens or companies was sued under the provision of the Helms-Burton Act, then they would be allowed to countersue in a national court. So the EU passed a law like this. Canada passed a law like this. Mexico passed a law like this. I'm going to show you the text of the Mexican law because obviously I'm Mexican. And this bit was... so before I explain this, the US also recognized that this was a very controversial law. And obviously, when other countries started reacting to it by passing their own kind of counter Helms-Burton laws, the US started granting a lot of waivers and suspensions of some of the sections of this act. So, for example, Title III eventually was suspended. The law is still valid, by the way. It hasn't been repealed. It's still in the books. But, like I said, many waivers and suspensions were added, including to Title III. So this is the statement of the Mexican government when Trump ended the suspension of Title III. And it's, it openly says that, so here, to counteract the extraterritorial effects of the Helms-Burton Act, Mexico has a law to protect commerce and investments from foreign laws that contravene international law, which has been enforced since October 1996. So it was passed just a few months after the Helms-Burton Act was passed. And among many other things, so for example, Mexican courts are required to refuse or recognize or enforce rulings or legal requirements or arbitration awards issued based on the Helms-Burton Act. And yeah, all persons are prohibited from providing any information required by foreign courts or authorities based on the Helms-Burton Act. And this is the key one. There exists a claims mirror by which individuals affected by the application of the Helms-Burton Act may sue in a national, that is Mexican court, the person who sued them in a U.S. court and request as damages the same amount of the damages assessed against them in the United States. So that's how these counter... these sort of mirror acts were made by these countries. So that was definitely, as bad as the embargo was, the Helms-Burton and the Cuba Democracy Act were so much worse. And it is really hard to not see these as an act of aggression against another country. The problem is whether economic aggression is codified in any way under international law. So that is the next point that we're going to discuss. Is this all legal under the UN system? So the first thing that we should note is something that everyone who's watching this video is probably aware of. That is almost every year, I think the only exception was last year because of COVID, but every year the UN General Assembly passes a resolution where it urges the repeal of the embargo on Cuba. And this is usually a resolution that passes overwhelmingly. So this year's, which passed, not too less than a month ago, in June, had 184 votes in favor to 2 votes against, of course, the US and its ally, Israel. And 3 abstentions, Brazil, Colombia, Ukraine, all of them basically US allies. So, does this have any actual implications on an international level? And the answer is sadly no, because the General Assembly, the UN is basically not a legislative body. It is a forum. And the General Assembly is a place where countries can go and express their grievances and, pass resolutions based on those grievances. But when it comes to anything regarding aggression, there is only one institution within the UN that is capable of taking action, and that is the Security Council. So let's see what the UN has to say about economic aggression, or sort of the justifications that the US is giving for its embargo. The first thing that is worth noting is that in the UN Charter, there is no mention of democracy whatsoever. None. Here's the full text. There is only one mention of democracy in this page, and it's not in the text itself. So literally nothing in the UN requires a country to be democratic. And that should be a bit obvious, because the UN was created not to promote democracy, but to avoid war. And if we look at the Chapter 1, the purposes and principles of the UN, unlike the OAS Charter, which specifically mentions representative democracy, the UN Charter at no point says that democracy is a requirement, either for membership or anything. To develop friendly relations among nations based on the respective principle of equal rights and self-determination of peoples, etc. I mean, the underlying sort of the common denominator of everything you see in the UN Charter is regarding peace, promoting peace, promoting diplomatic solutions, peaceful solutions to international conflicts. It has nothing to do with what kind of government you are. Now, what does this, membership. So, membership in the United Nations is open to all other peace-loving states, which accept the obligations contained in the present charter and are able and willing to carry out these obligations. So, no mention again of democracy, no mention of any type of political system or economic system. And of course, the UN does not expel members if they are not democratic. So, that should be obvious. So the requirement to be a democracy does not exist in the UN system. Now, aggression, Chapter 7. There is no mention here of economic aggression at all in any of the articles of this chapter. And even if there were, there's a further problem to this, which is Article 39 specifically says that the Security Council shall determine the existence of any threat to the peace, breach of peace, or act of aggression. So what does this mean? It means that it basically is up to the Security Council to determine if there is aggression or not, and to take the appropriate response to it. And what do we know about the Security Council? That the US has a veto on it. So even if it was determined that under the UN system, the embargo constituted an act of aggression, it would have to be referred to the Security Council, which would then vote, and the US would most likely veto it. So the UN system is essentially powerless to do anything about the embargo, because it can pass all the General Assembly resolutions that it wants, but anything that is actually related to aggression will have to go through the Security Council, and the US will undoubtedly veto it. And finally, there's Chapter 9, which is on economics, and again, there is no mention in this chapter of any kind of definition for economic aggression. So we see that there is a loophole here. We don't see, can we actually define economic aggression or not? And international scholars realized that this was very limiting. So in 1974, there were 2 General Assembly resolutions that were passed that are important to note. One was one that defined aggression, because aggression hadn't really been defined. And there is Article 3 sets a much more expanded definition of what aggression is. And unfortunately, none of them really deal with economic aggression. They basically expand the types of sort of use of armed force that could be constituted aggression, but they don't really go into elements of whether there is any, if economic activity can be used as a form of aggression. The closest one that comes to this would be point C of Article 3, which is the blockade of the ports of or coasts of a state by the armed forces of another state. But this still implies that there is an armed force that is being responsible for this, which is not the case with the embargo. Now, Article 4 says the acts enumerated above are not exhaustive, and the Security Council may determine that other acts constitute aggression under provisions of the Charter. So again, leaves it open. This would definitely open the doors for economic aggression to be considered, but again, it's up to the Security Council to determine it, and the Security Council will clearly not ever determine the US embargo to be an act of aggression. But that same year, another General Assembly resolution was passed, which was the Charter of Economic Rights and Duties of States. And I am somewhat proud to mention that it was Mexico that largely promoted this. So the Charter of Economic Rights, I'm not going to read the whole thing, but does include certain elements that would appear to codify economic aggression. First, I'm going to read Article 1, which every state has a sovereign and inalienable right to choose its economic system, as well as its political, social, and cultural systems in according with the will of its people without outside interference, coercion, or threat in any form whatsoever. So this would definitely suggest that any imposition by another country of what your political system or your economic model should be is well, you can't do it, basically. So by Article 1, the US would have no right whatsoever to impose its embargo under the justifications that it is giving. And the other article that is worth pointing out is Article 32. No state may use or encourage the use of economic, political, or any other type of measures to coerce another state in order to obtain from it the subordination of the exercise of its sovereign rights. So this one clearly defines economic aggression. The embargo would definitely fall under Article 32. But again, we face the same problem as with anything else that comes out of the General Assembly, that it is unenforceable. All of this has to be eventually referred to the Security Council, and the Security Council will not allow it to pass. So this is a bit disappointing. But yeah, at least under the resolutions that have been passed by the General Assembly, it can be made, the case can be made that the embargo is effectively illegal. Now, there's another element, and that is not just international law, but international trade. Is the embargo legal under the international trade system? And for this, we refer to the World Trade Organization, specifically the GATT, which is the agreement that underpins the WTO. And there is, obviously the WTO is a system that establishes certain basic rules for international trade. It is worth mentioning that Cuba is a member of the WTO. So by WTO rules, the US and Cuba would have to trade with each other under most favored nation conditions. But there is an Article 21 of the GATT that offers an exemption to this. And it's basically, this article is regarding security. And nothing in this agreement shall be construed, point B is the relevant one, to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests, And point three is the relevant one here, taken in time of war or other emergency in international relations. So this would appear to give some leeway in the U.S. in justifying that there is a security exemption for its embargo on Cuba. I should add the WTO is obviously not a big fan of sanctions. In fact, they've been quite open about this. There's an article here. I'm gonna link it in the description. I'm gonna link all of this in the description so you can read the whole everything. While economic sanctions may be attractive policy tools for governments wanting to express discontent with a country's behavior, it is arguable if, from an economic perspective, sanctions can achieve the change that is often envisaged through the punitive measures taken. In fact, the literature does not present conclusive evidence that economic sanctions are an effective policy instrument. So I broadly agree with this. I'm not a huge fan of sanctions imposed against an economy as a whole. So sanctions like the U.S. embargo on Cuba or other sort of broad sanctions like the one applied to Iraq after the Gulf War, those tend to hurt their populations and not really hurt their governments. And there's very few cases of sanctions of this magnitude being really effective. And the only one that really comes to mind is South Africa. And I think the South African case was something of an exception that you won't find on most issues today, in that the South African regime was basically doing, the apartheid regime was basically doing something so abhorrent that almost every country in the world opposed it. So there was broad consensus internationally on punishing the South African government. And you would not find that anymore because the only situation that I find comparable in terms of whether it would justify sanctions of that magnitude, I think would be the Israel occupation of Palestine. I think that would justify sanctions similar to the ones applied to South Africa. But this is not an issue where there is universal condemnation because the US would obviously not support these kind of sanctions to its ally. So, as for other sanctions, I'm far more open to the possibility of sanctions having some benefit in terms of when it's applied, for example, to certain leaders in an unsavory regime, because all these people eventually want to travel to New York and London and go shopping, etc., and their families. And so when they have sanctions applied to them for traveling to these countries or engaging in businesses, it often makes them, break from the pressure. And that doesn't affect the people in any way. And for example, in Venezuela, the sanctions, I know a lot of leftists are always arguing that US sanctions are the cause of the Venezuelan crisis, which is factually untrue. In fact, the first economic sanctions really were placed until 2019. Before that, they were only sanctions against members of the Maduro regime. Even then, they often don't work. So, on the whole, I think sanctions are far too commonly used in terms of just how really effective they are. But it's difficult. So the reason that I'm talking about sanctions right now is because we also have to discuss whether sanctions in a very generic sense, not just the US embargo on Cuba, whether sanctions as a policy tool constitute aggression or are legal. And in that case, I think it's very, very murky ground. But with regards back to the original issue on the US embargo on Cuba, whether it is illegal or not, I would definitely say that you can make the case that it is. I think that categorically it is very difficult to say that it is. But it is definitely something that you could make the case with the evidence that I have just supplied in terms of, there are certain General Assembly resolutions where the actions like the ones that the U.S. is taking against Cuba are clearly not acceptable. So you can make the case that it is illegal. But I still don't think that the legality of the embargo is really what the bigger problem, because when you read all of this, when you realize just how the sanctions fit into this murky legal quagmire, you realize the main problem is that economic aggression is not really codified, aside from that 1974 General Assembly resolution. But that's a massive loophole in international legislation, and it should be corrected, because I think there is a massive difference between putting sanctions on certain leaders of a government that is doing something wrong versus 60 years of a stranglehold against another country's economy for reasons that by now are not valid, because of the original reasons for the embargo. Half of them, which is Cuba's alliance with the Sino-Soviet bloc, is clearly not an issue now. So, and then there's the issue of just the discretion that is being used. Why is Cuba being punished for violating the principles of the inter-American system when all the other far-right dictatorships that have existed in Latin America since the 1960s, why have they not gotten an embargo? In fact, they've gotten U.S. aid. They've gotten U.S. assistance. They've been supported in every conceivable way. That is the hypocritical aspect of this. And I do think that this is reflective of these kind of loopholes in international law, and also the fact that the Security Council, being the only organization capable of taking action against aggression, is a deeply flawed one because of the veto that certain countries have. And this would work also. This works both ways. It's not always the U.S. doing the vetoes. Russia and China also veto every single issue that goes against their interests. And I should add that the USSR was guilty of using sanctions as well back in the day, back during the Cold War, when Yugoslavia broke away from the Soviet bloc. The USSR imposed sanctions on it. When Albania broke away from the Soviet bloc and allied itself with China, the USSR also applied sanctions to it. So everyone uses sanctions. It's not just the US. I don't want to give the impression. I know that a lot of leftists, the tanky / gray zone / Jimmy Dore viewers will assume that this is an exclusive policy of the West. That's not true. So, in conclusion, is the embargo illegal? I would say categorically no, but with enough evidence that a case can be made that it is. And more importantly, is it immoral? Of course. It has to end. Full stop. No question whatsoever. It is one of the most embarrassingly aggressive actions ever taken by the United States against another country. A country that is nowhere near as powerful as the US and really represents no strategic threat whatsoever to the US anymore. So by those standards, it has to go. And more importantly, rather than obsess over the issue of whether the embargo is illegal or not, I think we should really obsess why international law doesn't categorically make actions like this illegal, because that is a huge loophole and has other repercussions, because basically this still opens the door for these kinds of policies to be enacted in the future, not necessarily by the US, but by anyone else, and not necessarily against Cuba, but against any other country. So that is all I gotta say about this. Again, I will repeat my disclaimer. I am not an international legal scholar. I found all of this incredibly boring. And if anyone has more information to add, please include in the comments. If I got something wrong, please mention it in the comments. And yeah, if you like this video, please like, please share, Please subscribe to the channel. Most importantly, I cannot guarantee I will be making more videos on international law. I'm sure there is a niche somewhere for someone to become a YouTube celebrity making videos on international law. That will not be me. See you next time.